Uh, Okay, let me read the nomination letter to get the meeting started. Executive Council, Council Chamber, State House, Boston, Mass. Dear councilors, I'm pleased to nominate Daniel J O'Shea to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience. Sincerely, Charles D. Baker, and the vice is the Honorable Robert C. Ruffo. So we will begin the hearing by hearing from Judge. You have one witness, or two, or three?
So I have one witness today, and that's Judge Cunningham, who's physically with me in the office that I'm in right now.
Okay.
Would you like to hear?
We'll hear from Judge Cunningham.
Okay. Thank you.
Judge, it's good to see you, but has he left the room? Because I don't want you talking about him without him knowing.
I will only tell you the truth, Counselor, whether he's here or not. But Counselors, good to see you all, and thank you for allowing me to speak on behalf of my friend Dan O'Shea. My name is Kevin Cunningham. I was a district court judge for 25 years until last Friday, when I officially retired, and I believe Counselor Iannella was the only governor's counselor from my hearing way back when that's still on the council. But anyhow, it's good to see you all. I'm honored to have been asked to speak to you on behalf of Judge Dan O'Shea, First Justice of the Attleboro District Court. I first met Dan in 16, 17 years ago, although for a long time before that, my wife, Sheila, who practiced before the Industrial Accident Board, would come home all the time and tell me how great this Judge Dan O'Shea was in the Industrial Accident Board, and that I would really like him. He's a great guy. He's very professional, knows the law, and is a great judge to be in front of. So I had heard a lot about Dan before he even applied for the district court. And when he did apply, I invited him to sit with me in Taunton, just to come in and observe in the old Taunton District Court, which I know some of you counselors remember well. And so it was a late Friday afternoon. We were still busy, and Dan was in there observing when the judge on the bench at the time ordered a female defendant, to be taken into custody. And as the court officer went over to do so, to take her into custody, she kicked the court officer in the groin. He fell, she ran, and pandemonium broke loose in the courtroom. And it was quite a scene. And I asked Dan if he still wished to come to district court after all of that. And he enthusiastically said, yes, he did. So that was his introduction to the district court. And I'm very happy that he decided to join us, and he's done a great job. But Dan sat with me in Taunton, I think, for about 7 or 8 years, until he became the first justice in Attleboro. And I continued to work with him after that as first justice. I was the regional administrative justice for Region 2, which included Attleboro. And through the years, I became personally friendly with Dan, not just working with him, but also socially. And I got to know his wife, Donna, a lovely woman, a hardworking nurse, and their 3 great children. And now Dan is a proud grandfather. And through my personal and professional contacts with Dan, I've come to know him quite well. He's a devoted family man. I remember him rushing off the bench at 5 o'clock, well after the end of the normal workday, but would be rushing out to go to one of his son's ball games or his daughter's recital. And so I have respected him for being a devoted family man, a loving husband, father, and now grandfather. And professionally, he is intelligent, knows the law, runs a great courtroom, treats all parties with respect, and he listens, which, as we all know, is very, very important for a judge. He is well respected by his peers, and he's on a number of district court committees. And he's been designated as a mentor judge. I think Counselor Kennedy had just mentioned that he was Judge Lynch's mentor. But it's quite an honor, actually, when you're decided or determined to be a mentor that you would be instructing other judges in how to act, both new and deficient judges, if you will. And Judge O'Shea is on a number of district court committees, and he's just done a great job. As first justice of Attleboro, which is a very, very busy court and very inadequate surroundings, the physical plant is just terrible there. He's done an outstanding job as the first justice and the administrative head of that court. And I can honestly say, being a regional judge and also first judge, we hear a lot of things about a lot of the judges that are with us, but I can honestly say that all the years of working with Dan, both here in Taunton and in Attleboro, I've never heard anything negative about him. And that's very, very high praise indeed for any judge. As a judge, a retired judge as of Friday, but as a judge for 25 years, a first justice in Taunton for 20 years, a mentor judge for 15 years, and the regional administrative justice of Region 2 for 8 years. I think I know the attributes required of a good judge. And I can say to you today that Dan O'Shea is not just a good judge, but he is a great judge and continue to be a great, if confirmed, for the Superior Court. And Superior Court's gain is certainly the district court's loss. So I thank you, counselors, and happy to answer any questions that you may have regarding Judge O'Shea.
Councilor Kennedy.
Judge, it's great to see you. I personally am very sorry to see that you're retired. I had the privilege of appearing before you, as you know, multiple times in Taunton, in the old Taunton District Court. I think yes. Judge Moore was the DA when I first started going down there.
Exactly.
Back in the beginning of time. You were a great judge. You absolutely had the demeanor and knowledge of the law. You were fair to everybody who appeared in front of you. If the counselors wanted a model on who to put on the bench, you're it. You're going to be. I wish you well in your retirement. Thank you.
Councilor Duff, any questions? Okay. I just want to say, Judge, I can't believe it's been 25 years.
It's unbelievable.
I just can't.
I know. Time flies.
You know, as a defense lawyer, and Councilor Kennedy, I'm sure will agree with me, but when we go into courts and we walk into a courtroom and we see who the judge is, we either say, oh, we're going to have a tough day here, or it's going to be a nice, fair judge, and no matter what happens, we'll be listened to, and we will have respect for your judge. And you were one of those judges. When we walked in and saw you were there, we took a sigh of relief, much like Judge O'Shea, that, you know, we didn't know how it would come out, but we knew we'd get treated fairly and that you would listen to us. And you were very compassionate, in my view, to most people that came before you. So I thank you very much for that. And when are you going to have the retirement soiree?
Well, hopefully a portrait hanging at some point, if we can ever do them again, but maybe the spring, summer. So I'm hoping. Well,
you better hire, you better get a big room, because there'll be a lot of people there.
Councilor Jubinville.
Yes.
I just, I don't really have any questions. It's good to see you again. I took the plunge in 2014, so I've been gone for a while.
Right.
But I wish you well in your retirement. You had a great reputation, and I'm sure you still do. And I look forward at some point to maybe getting back together with the folks in the district court when they're back having the 3-day seminar at some point.
Right.
So good to see you. Thanks for your kind words, and wish you health and happiness in your retirement.
Thank you. Thank you very much.
Councilor Devaney, any questions of the judge?
Can you put the volume up?
Yeah, sure. Go ahead. You can speak.
Councilor Devaney, any questions?
No, I just wanted to say good to see you, and it's quite a tribute with you. You're the only witness to be called, and again, I echo, I hope you're having a great retirement. Not the best time, but hope we'll get through this.
Right. Thank you so much.
Thank you, Judge.
All right, counselors, thank you so much. Nice to see you all.
Always a pleasure.
Take care. Bye-bye.
Okay, Judge O'Shea, you're on.
Oh, okay, my opportunity to speak then. Terrific.
Opportunity.
The loudest it goes, great.
All right, thank you. Judge Cunningham is always a tough act to follow. I want to thank him for those kind words. I really am humbled when he talks about mentoring. I did not have an official assigned mentor when I came to the district court, but was unofficially looked up to Kevin as my mentor, and he's been a terrific colleague, and I will miss him dearly. But our paths will definitely cross in the future. I want to also thank, while I'm in the process of thanking people, I want to thank Lauren Green Petrino for all of her assistance, and Robert Ross for his assistance. And obviously, thank you, Mr. Chairman, for pulling this meeting together, and all the other members of the council. It's sort of difficult to do it remotely. I have a little experience before the council. I was before the council in 1992 for the first time, when I was just a young lad, really going through the process to be appointed to the Accident Board. A lot has changed since then. At the time, I only had 2 young children. I think my daughter, the oldest one, was about 2 or 3 years old. So I got appointed. I was nominated by Governor Weldon. This council confirmed that nomination. I was delighted to serve as an industrial accident board for 6 years. They were 6-year terms. Governor Salucci reappointed me. The council then confirmed me in 1998. And I was very fortunate to remain there. I became the senior judge, and in that capacity appeared before the council a lot through those years, and then ultimately was fortunate enough to be nominated for the district court in 2004. And things had changed remarkably by then. I had 3 children, their ages about 10 to 15 years old at the time. And when I took the appointment after confirmation by this council, I was delighted to serve in that capacity and really loved the job. Through the years, things change. I now find myself in the position where my daughter, who's the oldest one, is now my age when I first before the council. That's how things happen here. My family has expanded to include 3 kids, 2 wonderful daughters-in-law. Actually, one is technically to be because of COVID. The wedding this summer was put over. We have every hope that it's going to go forward for next year. One thing that could not be continued was the birth of my grandson. That, as you know, there are no continuances for that. So I had a grandson now added to the situation. So a lot has changed since I've been a judge and been before this council. But one thing that's never changed is my enthusiasm for being a judge. And that brings me here. I was delighted to be given an opportunity to serve as a district court judge and thought this was the pinnacle. I loved it. I dedicated myself to trying to do a good job every day. Did it for a number of years and was not really looking to do anything beyond it because I really found that it was very rewarding. But one thing that sort of shifted my focus was that I was a judicial mentor. I've been a mentor for probably the last 10 years or so. And that's been very rewarding. And as a result of that and other conferences and committee assignments, I've had an opportunity to go through and meet a lot of colleagues from other court departments. I actually worked on special assignments with the housing court, for instance, at one point, and I worked with other judges, in particular Superior Court judges. So several years ago, I had an opportunity to sort of look at that a little closer, decide whether I wanted to pursue the Superior Court. And quite frankly, I love the job of the district court judge. And so I oftentimes thought to myself, I don't really need to give up a lot. I've gained a lot by being in the district court, being on certain committees that I wanted to be on. I had my own court when I became the presiding judge in Attleboro and could put my mark on that court in the best way that I saw fit. But through a lot of efforts, Chief, I'm sure you all know Chief Justice Dolly and Chief Justice Fabricant of the Superior Court, and also Chief Justice Carey of the trial court. I was fortunate enough through their efforts to get an interdepartmental temporary assignment to the Superior Court about 1.5 years ago, and worked on some pretty serious cases, did some civil matters, some criminal matters, for a little over a month. And that really galvanized my resolve to pursue an appointment to the Superior Court. I realized I'm not giving up any parts of the job which I love, which is to judge cases, which is to be assigned complex matters, to try to resolve things for parties, and to try to do the right thing that I can in each and every case. So ultimately, that's why I sought the appointment, and that's why I'm here today. Now, this many years later, still actively enthusiastic about my job and my role as a judge. And I think I could make a valuable contribution to the Superior Court in much the way I was able to do that for the Industrial Accident Board for those years in the District Court, all told now to be 28 years. So with that, I look forward to answering any questions. We look for the confirmation by this council, if you deem it appropriate. Councilor Jubenville, I have you muted. Actually, I don't hear. Is everybody muted? But hopefully I'm.
Am I muted?
Not now.
Councilor Devaney? Councilor Devaney?
Okay, am I unmuted?
Yes, speak.
Okay. How nice to see you, Judge O'Shea. Oh my goodness, 16 years you came before me. Oh my gosh. You look great. I can't believe, and we have to think the children are 16 years older and you become a grandfather through the years. So it was such a pleasure to meet with you again yesterday, and thank you for coming out. I know it's a dangerous time, and I brought you in my very safe diner. So I thank you for that. I do want to say I'm sorry that you weren't allowed to come in the State House. I know you wanted to, but I think you're in a safe place, and because I understand what's happening in your court, if you want to talk about that. But first of all, I'd like to ask you about your experience on the Industrial Accident Board. Now, how do you feel, that has really contributed to your ability to be a judge?
It's a great question. I love that job. I took that at a very early age. I was really fortunate to have that appointment. And that is a full-fledged, hardworking judicial position. It's an administrative position, so it's not obviously a part of the judiciary. But for all intents and purposes, you are acting as a judge day one. There are complex matters, real matters of serious importance. Literally the lives, the economic lives of the people and the businesses that appear before you. So there's a lot of similarity. You're judging cases, you're trying to deal with complex issues. In the days that when I got appointed, there was a really serious backlog of cases. And so our charge was to try to get through that backlog, to move the cases, to try to be as fair and equitable as we could, knowing that each and every case that we dealt with, each one dealt with the lives of people, their families, and their businesses was very important. So it was a terrific, and it's not a training ground as such for a judge in the district or Superior Court or any other court, because it is in and of itself judging. So I never wanted to create the impression that it was like a training ground for another judicial position. I was fully satisfied in doing that job in handling those cases. Ultimately, there have been several people that have moved on from the Industrial Accident Board to the District Court, but prior to the time that I went, there was not a lot, and so it was a job that I really enjoyed, and I know that the people over there work very hard. And those terms are reviewable every 6 years, so there's a whole statutory recognition of the importance of those positions that I think. It just shows that they have to go through the same process as a judge in the judiciary, nomination panels, advisory council, and ultimately appointment by the governor and confirmation by the governor's council. It's that important. Right. Well, you certainly did an outstanding job. I know I was there at the time when your last couple of years. But the thing I have said over and over, I look for empathy and compassion, and that certainly is especially on the Industrial Accident Board, to have compassion and empathy for those workers who are trying to put food on the table. So when did you think about moving from the district court after 15 years? So I had not wanted to leave the district court. The collegiality that we have in the district court is incredible. The support that I received from my Chief Justice, Dolly, and his support staff, they have a legal team that gives us a lot of support. At the local level, our regional administrative judge, who for me has been primarily Judge Cunningham, the support has been terrific. So to leave that was a big deal. And so I would get a little nudging from time to time. I'd see some cases or I'd work on different committees. And so I was interested in what they do in Superior Court. But to me, the trade-off was a risk. And it was one that, given the circumstances of my own court and the fact that I was given these increasing responsibilities, I kind of felt like I'm good. I don't need to sort of go anywhere. I like what I'm doing here. But then through the years, I would realize that there'd be things that would interest me in the Superior Court. So, candidly, I had often said years ago, it's too bad you couldn't just go try it out for a little while and see how it works. And we all would laugh about that. And of course, appointments don't work that way. But years later, which brings us to about a year and a half ago, as I mentioned, I had this terrific opportunity. There was a need in Plymouth, the county of Plymouth, but in particular, the Brockton Superior Court. And so that need arose with some retirements and some other sort of mechanical issues that took place. And so I seized the opportunity and said, this would be terrific. I'd love to go over. And my court has some great people that work there, and they were able to cover. None of us, though some of us tend to think that we're important, none of us are irreplaceable. And I found that out in the 5 weeks. When I left, my court did fine. I was able to get through emails and texts and all that stuff. But the other judges that rallied around in the clerk's office and the probation department, security department that we have over there is terrific. So they all were able to work through. And it just told me that it's the subject matter, plainly, that interests me in the Superior Court. Plain and simple. In the district court, our cases, we get a lot of cases. It would be very typical pre-COVID to have a courtroom full of people. We could easily approach 100 people in one courtroom in one day that we have to deal with. Cases. Crazy. So with COVID, that's a whole other circumstance. Superior Court doesn't have the volume, but of course the gravity per case is much more substantial. So we have a lot of more cases that need perhaps more deliberation, more efforts, larger jury pools, longer periods of time to get cases to trial, et cetera. Or cases tried, I should say. So it's just plainly the subject matter that has drawn me towards seeking a Superior Court appointment.
Well, I want to thank you for being a mentor. I don't know who established that, but it is great. We had, only Counselor Ainella was on at the time, but we had someone that came through that to a district court, only had 20 hours that she worked at home. She never was in court. So I never got calls like this before, and other counselors too. She was very rude to everyone. And so anyway, I have been following up through the years, and the mentor program has helped. She is, she's come along. So, you can't teach temperament or demeanor, but I really think that mentor program has helped a lot. And you know what? I wish they'd have it for the older judges too. But anyway,
there's a little bit of that.
Not all of them, but some of them. But now, let me ask you. I mean, you have to make decisions, but sometimes the decision is made for you from the jurors. And that has to be difficult sometimes when you have a different opinion. Can you tell me one or two, trials that you had to sentence and it was very, very difficult for you?
Sure. In just referencing our discussion, I know oftentimes there's a temptation to ask, what's the most difficult case type that you've had, or can you remember any difficult cases? And it's funny because I have a niece who's a student at a very good university who called me the other day as part of a research project and asked me a similar question, saying, do you ever disagree with what the jury says, or what is the most difficult type of case? And the example that I used, and I know we talked about this recently, was a motor vehicle homicide case, where we have a situation where just a momentary turn of the wheel or a little slip of attention results in catastrophic results. So unlike perhaps an assault and battery case where there's an aggressor and there's a victim, where it's easy to sentence someone as part of a punishment aspect. When we have motor vehicle homicide cases, they're particularly difficult because oftentimes they're people that just haven't done anything other than what would normally be just maybe a citable offense as leaving in marked lanes or maybe speeding or something like that. Something that's not reaching the egregious level of criminal behaviors that we have to punish in other contexts. So those get difficult. And sometimes when a jury comes back with a finding, we have to sentence somebody. We have to take into fact all the considerations. What are the issues of punishment, rehabilitation, deterrence, all of those factors that go into play. And some of them fit really easily with certain criminal offenses, and sometimes they don't. And motor vehicle homicides are situations where, the punishment aspect, deterring somebody's future behavior or rehabilitating them so that they don't reoffend, all of those factors are looked at very differently than other types of criminal offenses.
Do you, you have so much experience from the Industrial Accident Board and your 15 years as a district court. Is there anything that you feel there's going to be a learning curve for you to go up to the Superior Court?
Absolutely. Maybe it's because I've got 28 years of being called a judge, that I'm as nervous now about this appointment as I was as a young 31-year-old kid going to the Industrial Accident Board, because I realize how much I don't know. And any judge who served for 5, 10, 15, 20, 30 years will honestly say there's a whole lot that they don't know. Unless they're sort of glossing over things, there's a lot to learn. There's so much. And my 5 weeks over in Superior Court told me that while we do a lot of things in certain ways in district court, Superior Court is very different. So there's going to be a big learning curve. And I'm glad that you mentioned the mentoring program, and it's been a terrific program. I am looking forward now to being on the bottom of that T in the mentoring program that I embrace. And I've talked to Chief Justice Fabricant, who's been sort of rolling out some terrific programs for new judges there. And I expect to take advantage of every one of them, because knowing that this is still judging, and as you said, you can't teach temperament, but you can learn from your colleagues. And the outpouring of support that I've seen so far from the Superior Court colleagues has been terrific. So I look forward to becoming part of that mentoring program as a new.
No, I saw that in that particular woman who was voted by the council. And I know one of the councils had gone before her and she was rude. And I also talked to people in the court, and as I said, she had never been in a courtroom at all. And so one of the correction officers whispered to her, wanted to help her out. And she shouted out, "Don't tell me what to do, I'm the judge." So mentoring has really come a long way for her. So that's not the kind of temperament we want. But I can't tell you how excited I am that you're going to the Superior Court, because the council voted for someone with 6 trials in 21 years in the Superior Court. And you will be such an asset, such a mentor for someone like him. And I just, I couldn't be more happy that you made that decision. Now, tell me about the Hernandez case, and how did that get to come before you in the district court?
Invariably, when I go out or see people socially, it's amazing how sometimes someone will be introduced and they'll say, "Oh, he's a judge over in Adler. Oh, by the way, you did that in his case." I want to be clear. I did not handle any of the trial. That's a Superior Court matter.
Oh, I know.
Perhaps that's illustrative of how the district court is different than the Superior Court. A lot of times, indictments aren't sought for a period of time. So when there's a criminal charge, like a murder or something along those lines, the complaints start out in the district court. So in my particular court, which, as Judge Cunningham alluded to, is a very overcrowded, smaller physically courthouse on the border of Rhode Island. And that case was catapulted that little court onto the international stage overnight. We're not equipped to handle 15 or 20 TV vans, to have all major newspapers. I mean, literally, our clerk's office got a call from the BBC asking us if we could hold off on the arraignment for a few minutes while their representative got there. I mean, it was just really a media event that was, because of the whole dynamics of the case, really affected us deeply. So there was a lot of arraignment issues that had to take place, a lot of search warrants that had to be done behind the scenes. We had the defendant, wasn't just that defendant, but there were other two co-defendants who were charged, who had to go through the process. There was a lot of press issues, First Amendment versus ongoing investigations, and not to get too technical about it, but there was a lot of rulings I had to make regarding the dissemination of public information. So with all that sort of whirlwind taking place over the course of the summer of 2013, it was pretty remarkable. Eventually, each of the three co-defendants were indicted and arraigned in Superior Court. And when that happened, for all intents and purposes, most of the stuff in the district court was done. There were some warrant issues and things like that I recall. But I was very fortunate because I had the support not just of our legal team in Boston, but also my court staff. They were professional to a person. The local police department and working with the state police department were terrific. They did it safely so that we were able to conduct it in a dignified manner with all of the live streaming and all of the things that you don't get a chance to do over if it doesn't go right. We were concerned about security. We were concerned about public displays of emotions outside the courthouse. A lot of things going on. So ultimately, it showed, I think, to us in the district court that we're capable, certainly, of taking an enormous case like that and trying to get our part of our responsibility done in a dignified and fair and expedient manner.
Okay, now the $60,000 question. Why was it you waited 15 years to move on to the Superior Court?
I want to get the application right. No, Kim, of course. I mean, honestly, you know, our age is rolled out there, so everybody would know if they read my application how old I am. And so knocking on the door of 60, the question is, why do you want to change career directions now? And I think that career judging, there's a little bit, I think, that our country, perhaps our state, could learn about how they do it in other countries. We don't have career paths for judges, typically. I mean, typically, I think years ago, a judge was appointed later in life, maybe age 50 or something like that. They did their 15 years, they retired at 65, and out they went. The concept being a very experienced lawyer generally might transfer to be a very good judge. True in many cases, not always true. I came at it from an entirely different perspective. I came in and actually made the career out of judging from my early 30s all the way up to now. So the district court it's a sort of rough and tumble place. I suited for it to get up in the morning and get energized by the list of all the cases, and sometimes just surviving the day was the agenda. You had so many cases coming through. We'd have to try to make quick decisions, spontaneous decisions, be fair, and ultimately through the course of that career, it's very rewarding. So I had no reason to leave, but it really becoming a mentor 10 years ago got me introduced to all the things that our courts, that people do, and that's what made me interested. And you know, as I said several years ago, probably about 5 or 6 years ago, which would put me at about the 10 or 12 year mark on my district court career, I did consider the Superior Court. But frankly, the trade-off of going from giving up all the committee assignments that I had, my own courthouse, and all the things that I was doing, plus being very busy with what we did, just told me I really saw no need to do it. And then as life evolves, and I find myself now taking on different roles, who would have ever thought to be a grandfather? But here I am as a grandfather. And so that's what made me lead towards this. It's an evolution in my own career, my evolution of my own sort of personal life that's led me to believe that I could do well at the Superior Court.
Well, you have it all. I mean, you have criminal, you have, civil. I like your writing. Tell me about that, about the Jose and Maria Andrade.
Oh, so right. Of course, the council asked to give writing samples, and it's funny when you think about give an important writing sample, and when you do so many cases. I mean, in looking through my record, I think I had over 600 jury trials on the.
Oh my God! Wow.
So, and of all the writing that I've done, I mean, I've saved some when I transferred over from Taunton to Attleboro. I have stuff on a disc.
Now, that was a Superior Court civil action, that particular one, right?
That's why I put that out there. So the question is, so a lot of my old writing, which some of them are very good, but they're on a floppy disk. I couldn't even pull them up on a floppy disk. I have no idea where they are. So what I decided to do was give two samples of sort of different. So one was when I was on the appellate division of the district court. I served for 2 years on the appellate division and handled not that a commercial lease is anything that I thought would really excite members of the council, but it was a decision that I did while on the appellate division. I wrote several, but I did that for only 2 years and then became presiding judge and really was happy to sort of pass the baton to another colleague. And I gave the other case because I did it in Superior Court while in the midst of a very serious aggravated rape trial. So that case, I only threw it out because it came to me on a very quick, in the middle of a trial matter that I had to go through with a Spanish-speaking pro se person who didn't know it, but he stumbled upon a very complex easement issue. Now, most people who do criminal work, when you say the word easement, they blank. Nervous about that. I loved it. I thought it was terrific. Knowing, if you read the procedural history of that case, there were several other Superior Court judges, one of whom took a view, actually went out to see the place. It was a place over in Brockton, and it wasn't that far from the courthouse. So one judge actually went out, looked at it, made some rulings. Another judge handled the motion. I don't remember exactly what it was. So I was the third Superior Court judge on this Spanish-speaking pro se litigant's case, which was hugely important to him and to his next door neighbor. And they didn't realize it, but they both were stumbling on a very complex legal matter. So ultimately, that's why I put it in there. I thought this is sort of interesting for anyone who does civil. They'll know that at least but they wouldn't know during the midst of a very serious trial where I think I impaneled 122 jurors for that case, took about a week and a half. I did that whole motion and the decision really proximal in time to that trial. So that's sort of what we do in the district court. We don't have the luxury of saying, I'm going to block out an entire month and a half to write a decision. Usually it's in the context of doing a first session where you can be processing 50, 60, 70, hundreds of cases sometimes, while you still have this thing that you have to get out because the parties are waiting for a decision. So it's just an example of kind of how we approach a lot of these cases.
Right. No, I appreciate that. Now, we talked, and thank you for all the time that you afforded me yesterday. I'd only keep you in a safe place. And I've got to tell you again, I'm the Maytag repairman. I'm the only one here in the State House, and I was so hoping that I would see you in person, but it's good seeing you this way anyway. But okay, now I know with this pandemic, the courts are so backed up. I know in Woburn, they have missed 1,800 trials. I know yesterday you were telling me, the predicament you had in your court, attorney came in who tested positive. How can you prevent that? I mean, I think no one should come into the State House unless they're tested, but I don't know. But I don't know how you can do that in the courthouse because you don't know who's walking in, right?
Well, it's a great question. And obviously there's a tension between safety and our awesome responsibility, which is to get cases addressed. And, I would say this as a mentor, and I remember doing this at the Industrial Accident Board as well as a district court judge. Nothing happens unless we decide it. So there's no appellate rights that can be exercised. There could be no other forms of relief. So while you're deliberating on a case, nothing happens. So that's not fair. So ultimately, we as a system have an obligation to address these many, many, many cases that have come before us. So there are a whole lot of people whose responsibility is to consider all that. Smarter people than I and committees and teams that have put together processes to try to deal with this. And most of the things, as most of us would anticipate, are a compromise. So initially, COVID happens. We all think it's going to happen. We'll just deal with it. We have to shut down for a period of time, reopen as quickly as we can, and do this all safely. And of course, there's been nothing but controversy along the way, both at the local level, even the international level. Look at what all the countries are doing across the globe. So the court system has to try to address those cases while also trying to keep people safe. So the systems evolve as knowledge evolves about the disease process, about the cases that we have. And as you see, each court department has rolled out their own standing orders, and they've evolved over the course of the summer, right up to the SJC. There's been the orders. And so our responsibility as individual judges, and for me, I have my charge was the whole courthouse over in Attleboro, is to try to keep consistent with what the standing order would be, and that is to try to roll out cases the best way we can in the most fair way that we can, making sure that our staff people are trained on social distancing, on masking, on hand sanitizers, and it means coordinating with the county. Our buildings are county-owned buildings, so we had to coordinate with the county, or if it's a state-owned building, they coordinate with their people, and we check temperatures. We do intake as people come in. We had to coordinate with local police departments about how to get people in custody to the court and how to deal with that. We've had to deal with the houses of correction, even the prisons, the cases that go to Bridgewater or Worcester Recovery Center. All of that requires a huge effort to try to get people to do the jobs that they can to make sure the courts can carry out their mandate. It's real complex. And I certainly, I'm not going to throw an answer out there because I don't have one. But what we do is we take each day and sort of see how it survives. So all of our staff people in my courthouse, and I know I can speak, I'm in the Taunton District Court here today. People are wearing masks, they have hand sanitizers, people are trained on handling files. We want to minimize the amount of exposure for the public and for the litigants that appear before us. We do a combination of Zoom hearings as well as some telephone and some in-person proceedings.
Right. So how is that working? You're working out of the Taunton court, right?
Oh, just today, and that's because of a series of things. And I'll tell you frankly, I could go over to my court now, and I was prepared to attend this meeting in my court.
But when you had the attorney that tested positive, you had to move to the Taunton court, right?
Yeah.
So what happens? Everyone comes, all your staff and everything. How do you remedy that?
So what we do is so in our court, it was last week, there was an exposure. So we got the information and nobody attended the courthouse at all for 2 days. They did a deep cleaning and people were advised. So nobody went to that courthouse for those couple of days. The people who were exposed, who potentially were in the same company as this particular, it was a lawyer as a member of the public. Sometimes it's a staff member that has an issue. And what the cases do is they come over to a courthouse. Now, it just happened to be coincidentally that I was in this building the day that occurred. So I was able to take those cases, and we literally took people who were arrested, and the police departments were terrific. Instead of bringing them to the Attleboro courthouse, they brought them to the Taunton courthouse. And this is replicated all across the state. This is nothing unusual that we did. Courts do it all the time. I think Taunton was closed at one point, and we accepted their cases. Brockton was closed at one point. We took some things. We helped out Brockton. So we do what we can to try to keep the business going. And the cases, we make sure that if there's emergency restraining orders, things like that, that there's a judge available to handle those on the phone. And it is truly a collaborative effort between the clerk's office, the security departments, probation office, and the different judicial departments.
Well, I'm just so pleased that, you have the experience and all the years, that you can bring there. I regret we've lost 2 this year. We've got to change that 70. Keep asking, and I'm going to keep on asking. And, Judge Rufo, a wonderful judge. I voted for him and proud to. And also Malcolm Graham. And I don't know how many people know about Malcolm Graham, Judge Graham. We talked about him yesterday. I met with him at the diner. Most humble person you could ever meet. On his resume, because the present counselors weren't on at that time. On his resume, I have to tell you, under employment, he put work for the Celtic organization. So what would you think? Equipment manager? He had 2 rings. He was a player. He was a player for the Celtics. And just one day he said, I'd like to be a lawyer. And he never mentioned it, meeting with me, a hearing. And just recently, they tell me in the Superior Court, he has mentioned it to people. But, we're losing so many good people. That 70 is ridiculous. I mean, if you can be a recall judge at 75, the same person, but you're forced to get out in 70, look at the wonderful people we lost at the SJC, you know? Well, anyway, I'm venting and it has nothing to do with you. But I can't be more ecstatic when I saw your name and I thought, 15 years you've been, it was 16 really when you came before the council, wasn't it?
Right.
16 years. Wow. Where did those years go? But I'm ecstatic and I'm just so proud that you did apply because we need you. We need someone like you with the experience to replace these people who have served us well. So it's a pleasure and I'll be looking for, I usually don't say, but I'm proud to vote next week for you. Thank you.
Thank you. Councilor Duff.
Thank you.
Thank you.
She's muted.
Councilor Duff.
Gotta unmute.
Can you hear me now?
We can hear you.
I apologize for that. Running my mouth. Good to see you, Judge
Thank you.
O'Shea.
Same here.
I wanted to ask you a little bit about, I think your experience as a district court judge will inform you in the Superior Court.
If I only caught part of that, was the question, how will my experience in the district court guide me through the appointment of being a Superior Court judge? I only got part of the question.
Well, how will your experience as a district court judge inform you in the Superior Court?
So I think it will be a huge asset because in both capacities, whether it's district court or whether it's Superior Court, the responsibility is to take the case as it comes through, to try to, number one, be prepared. Number two, to try to understand as best you can what the positions are of the parties, and ultimately to try to resolve as many complex issues along the way to ultimately get the case solved. District court is high volume, high intensity, a lot of decision making in sometimes really, really adverse conditions.
So I don't know.
That tempers a person over the years. And I think that when we do those cases and we have that experience, trying to keep our staff together, trying to understand the complexity of each case and to try to come up with a reasoned decision, that translates equally well to the Superior Court. The nature of the cases in the Superior Court can be different. For instance, you can't do a medical malpractice case in District Court. If we were to do that, we would have to shut everything down. We couldn't do it. We couldn't simply, even if we had the jurisdiction, logistically, we couldn't do it. So there are limitations. Superior Court, you are able to do it, but you still have to have your staff people in the courthouse. You have to be able to do the preliminary matters, the pretrial matters in a way that's fair, and you have to make rulings and be consistent and understand the law. So to me, it's directly relatable to what goes on in the Superior Court. The subject matter may be different, but ultimately the role is identical, and that is that you have to take each issue as it comes through, try to be fair, try to understand the issues, and be prompt in decision making. And as I said earlier, one of the problems I found with most judges want to do a good job, and they have a sense of doing the right thing, and they know the law, and they're smart people. The difficulty oftentimes comes in actually doing it, and that's where my experience in the district court, I think, will go a long way towards success in the Superior Court. We have to get things done. We can't sit back and think about a case for a long period of time. We've got to get it done. And so I think that sense of getting to the end result is an important thing. But in particular, Superior Court, because they've got, people are waiting on decisions there as well. And so that's, to me, the real challenge is to try to keep above that, to try to get the matters out as best you can for the parties. Because until the judge makes a decision or a ruling, the parties can't do anything about it. After that rule, if they don't love it, by definition, we're not in the business of making everybody happy. But we want to do what's fair, what's right, and if the parties or somebody wants to agree, disagree, and sometimes both parties might, they'll at least have an opportunity to go to the next level.
Have you witnessed or experienced any racial profiling, not just in the courtroom, but in jury selection?
Well, it's interesting that you say that. There's been a lot of cases that have come down, more cases than I can recall in recent memory, that have come down in the last several months dealing with just that issue. We've had and not to get too technical, but the bats and swords challenges and how jurors are to be selected. And we have a mandatory individual voir dire, for instance, if there's a racial issue between, say, a black defendant and a white victim. So there's all these things that have been kind of built into our system of jurisprudence that's designed to try to identify if that's something that takes place. Because above all else, we want to make sure that the jury process is fair. And we now in the district court, we rolled out probably, I would say maybe 2 years ago, actually part of our jury instructions where we're instructing jurors on the concept of implicit bias, which, through the years I've been trained even at the Industrial Accident Board, going back in my 28 years of total experience, we had a lot of National Judicial Conference educational programs on implicit bias and things that are related to racial bias throughout the years. So it's important that not just we as judges understand that it's out there, but that we make sure that it's embodied in the process itself. So when we impanel jurors now, it's not good enough to say, well, you just get a peremptory challenge, no big deal, you walk away. Now the case law that's evolved significantly within the last year has told us, no, not good enough. We need to probe. We need to make sure that there is a race-based decision in trying to challenge a juror. We're actually telling the jurors, where we never did this before, that search your own conscience ahead of time. Understand that implicit bias is potentially in all of us. And so the question is not, can you be fair? Everyone, I think most judges, you say, can you be fair? Sure. Or you talk to a juror, say, can you be fair? Sure, I can be. I'll be the fairest person around. That's not good enough under our system of jurisprudence. We've got to probe that deeper. And so to answer your question, yes, there have been definitely cases that I've seen during the course of jury process where that issue has come about. And so it kind of, if it comes to our knowledge, it's easy to deal with. The juror says, sure, I can't be fair because I'm racist. And believe it or not, we see that on questionnaire sometimes. And maybe that's the person just wants to get out of jury service. But they put on their questionnaire, I'm a racist, I'm a white supremacist, or I belong to hate groups. And obviously that poses a really serious problem for jury selection.
Well, do you believe that people should be tried by a jury of their peers? And if there are people of color as defendants in the court, are they getting that? Is that right being attained?
So, yeah, I mean, again, a question that is difficult to answer in a lot of ways because I've had experience. And again, I think as I look through my numbers, I keep a journal, and I was over 600 total trials in my career in the district court, about half of which were bench trials and about half of which were jury trials. So even if you took roughly 300 jury trials in the course of 15 years or so, during the course of those trials, there have been instances where I had one that comes to mind, for instance. There was a black defendant, a white victim, dealt with a sexual assault case on a child, serious matter, and the defendant couldn't get a person of his own ethnicity on the jury panel. Now, I'm in Bristol County, and so the jury pool is what it is, and so we had the case on for trial. We have a very small jury pool in my courthouse. It's just the way it's designed. I don't have any direct involvement with that. So we get some days 15 jurors, 14, 18 jurors. So it gets difficult. So what we did, there was a racial challenge to it. We didn't get it. There was not one single person on that jury pool that was of the same minority status as this individual. So I allowed a request to continue it. The case was put on for trial 3 times. And in that 3 times, there was only 1 or 2 opportunities to have somebody of the same race. Ultimately, the case was tried, and it resulted in an acquittal, and that was it. But the question there is not, is there something wrong with the process? Because the process, I truly believe, and we've gone to different educational programs and heard from the jury commissioner's office, and it's truly a random snapshot of people for jury service. But in those situations, there sometimes can be difficult outcomes because of just the snapshot that's taken. And so we can't assure everybody the right to be tried by a jury of their race. And I'm not sure that would be a...
Well, your race isn't necessarily your peers.
So, right, so
It's a much bigger issue than that, than just
It-
race. I mean,
it is.
that's part of it, but that's just one part of it. And we are all implicitly biased. I mean, that's what implicit bias is. It's implicit, right?
That's the whole idea.
So, I mean, every single one of us, even those of us who come from mixed race families, have our own prejudice. I mean, it's just, that's a fact. And to say that we're not is a lie. And that's, I believe, and this is my belief, and others could disagree with me, but this is across the board. I mean, this is, and I'm not going to go on with this anymore because this is almost more of a philosophical question, which I could take an awful lot of our time. But it is really one of the most burning questions of our day with justice in our courts. And you're right, we are not we don't have as many people of color, but there are other ways that is measured as well. Anyway, well, that will be the rest of my questions. Thank you so much, Council Jubenville.
Thank you. Councilor Jubenville?
Minute. Hello. We're going to be breaking, I believe, for the General Assembly at 11 o'clock. Am I right on that, Lauren?
Correct. We'll be starting assembly in about 1 moment.
Okay, so we're just going to go on a little break from the session, Judge. You're free to enjoy the General Assembly.
Councilor Jubenville.
We'll get right back to you.
Councilor Jubenville. Can you hear me?
Yes, I can.
I was just wondering if I could just make a statement. I'm actually in Taunton Court waiting to be called for trial.
You can make a statement.
So I just wanted to say that I spoke with the judge and I will be voting for him. He's a superb choice. He comes highly recommended by so many people from so many different walks of life. So I want to thank him for stepping up to offer to go to the Superior Court. You don't see that often with district court judges. So I'm pleased to vote for you next week, sir.
Thank you.
Thank you.
We're going to begin the,
It's terrible. I can't even hear them. It's very hard. I tried to hit that, but it didn't do anything.
we're going to be starting the assembly really soon.
Could you hear me?
Yes, I can hear you. You want to start the video?
Oh, jeez.
You're fine, you're fine.
That's okay. That's all right. I'll take you over that. I'll take you over.
All right, move to the other room so they can hear you.
It's like having a staring contest.
So I think the nominee today is actually in Taunton Court doing his hearing.
You know, we're busy here today. It's crazy.
Mm.
There's
So-
no writing though. It's good.
Are you in Taunton, Joe?
I am in Taunton, yes.
I think he said that in the beginning.
I don't have the office that the judge has though. I got a conference room.
Well, that's good.
It's good, yeah. We're getting things done. Hopefully get a trial today.
How many judges there today?
2, I think. McManus is downstairs, and I think I heard Horahan's here. I'm not even sure.
Well, if you see Judge Horahan, tell him I give him a solid C+.
All right, I didn't put him on. McManus did well though downstairs. He's doing fine.
Judge Horahan's brother lived across the street from me for 25 years. Oh, here we go.
Oh yeah.
Cheers.
Hello, LG.
Okay. Let's see. Good morning.
Good morning.
Good morning.
How's everyone doing today?
Good.
All right. Do we have everybody and do we wish to start? Okay. So I'd like to call our assembly to order. I recognize Councilor Kennedy for our prayer and pledge today.
Good morning, Governor. Good afternoon. Good morning, Governor. We obviously, many of us had a very, very late night last night. And we still don't know who the President of the United States is going to be in January. But I just want to say that no matter who it is, that we all pray that somehow whoever it is able to govern and bring this country together, because what's very obvious about what's happening with that vote is that the country continues to be incredibly divided. And I hope whoever's in the White House in January is able to bring us together. And that's what I ask us all to pray for.
Amen.
I pledge allegiance to the
The
flag
flag of the United States of America
and
and to the republic for which it stands,
One nation.
under God,
God, indivisible, with liberty and justice for all.
Okay. I recognize Councilor Hurley for a motion to record advice and consent for the financial warrant.
So move.
Second.
There's a motion and a second. All in favor, say aye.
aye.
I recognize Councilor Ferreira for a motion to record advice and consent for the pending list of notaries public and justices of the peace.
So move, Governor.
Second.
There's a motion and a second. All in favor, say aye.
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 Bob, I just want to point out you're muted.
Okay, thanks.
That's what friends are for. I recognize Councilor Duff for a motion to record advice and consent for the appointment of Stephen B. Gary to the position of Associate Justice of the Lowell District Court.
It's with great pleasure that I make that nomination, Governor.
I second that.
Second.
And Lieutenant Governor, I just like to speak on this nominee. I have to thank everybody. I'm so glad that he reapplied because sometimes when someone is not appointed and they see who was appointed, they don't apply again. And he did. And we would have lost someone really great. He has everything that I look for. Besides being an outstanding judge, he has compassion. He has empathy. He's just what we need on the bench. I'm very proud to be voting for him today.
Thank you, Councilor. Okay, we may commence the roll call.
Counselor Duff,
Yes.
Counselor Kennedy,
Yes.
Counselor Hurley,
Yes.
Counselor Ferreira,
Yes.
Counselor Jubenville,
Yes.
Counselor Devaney.
Yes.
Okay. All right, we have a new nomination. We were proud to nominate Justice Dalila Wendland to the position of Associate Justice of the Supreme Judicial Court. Yesterday, you heard her accept that nomination, and we'd like to schedule a hearing for Justice Wendland. Would you have a date in mind for that?
Whose is it?
It's Councilor Devaney.
I'm sorry, I didn't hear you, Lieutenant Governor. No, it's a busy time. It's Thanksgiving and everything. So the day I could see would be the 18th
Perfect.
Okay.
at 10 o'clock.
All right, the 18th of November at 10 o'clock. All right, I know you have a busy schedule. It's a lot on your plate. So thank you very much for your hard work. Got a lot of important positions to fill. And I know you have a hearing underway now with Attorney O'Shea. So thank you very much. Have a wonderful day.
Thank you for your hard work, Lieutenant
Stay safe.
Governor.
Okay, thank you. Bye-bye.
Thanks.
Okay, we'll get back to the meeting. Judge O'Shea. There he is. Mr. Duff, are you all set?
Bob, we're having trouble hearing you.
Can you hear me?
Yes.
Okay,
Yes.
Councilor Hurley. Councilor from Western Mass, Councilor Hurley.
Good morning. I just, we spoke at some length, Judge O'Shea, and we actually spent some time serving together. You've got a great reputation, as I indicated. I think you're going to do a great job as a Superior Court judge. And as one judge who found another calling in life, that is being a governor's counselor, perhaps that's in your future too. One can only surmise.
We'll see.
But seriously, you're a great candidate. I think you're going to do a great job on the Superior Court. And I congratulate you for your courage in trying something new. So I'll be voting for you next week. Thank you.
Thank you,
Thank
Councilor.
you, Councilor Hurley. Councilor Kennedy.
Just a couple of questions. Two issues I'm going to touch on. One is that Councilor Devaney touched on the issue of COVID and how the courts are handling it. I'm very, very concerned about that, and I've been speaking to a number of the district court judges, especially about that, because I think the district court and the Superior Court has done an incredible job of getting up to speed in terms of technology, in terms of getting things done on Zoom and WebEx and everything else, and bridge lines that I'm not a fan of. I don't like the bridge lines at all. I had a very bad experience with that in the Taunton court, where I was never unmuted, and there was a restraining order that took place and one issued for a very long time against my client because the clerk forgot I was on there and didn't unmute us. I had to file a motion to get the whole thing undone. It was extremely unpleasant, took a lot of time. I was trying to be careful not to put any blame anywhere because I recognize it's a new technology that we're dealing with and mistakes happen, but it created a lot of stress for my client. And related to that, there are a number of Superior Court judges that are trying to push lawyers to do evidentiary motions over Zoom. Judge Budd heard an appeal from one Superior Court judge where he ordered the defendant to do a motion to suppress over Zoom. She stated pending a hearing. Judge Gaziano heard a separate appeal, 211-3, related to the fact that a judge had ordered the defense counsel to go forward on Zoom on a motion to suppress, and he denied the stay because the Superior Court judge said, well, if you want to come in and do it in person, you can do it in person, but otherwise I'm ordering you to do it on Zoom. That doesn't give the folks involved in the evidentiary motion a real option, because some people are putting their lives in danger by going into a courtroom and choose not to do that. I know as a defense lawyer, I don't want to do anything that's substantive over Zoom. I don't want to cross-examine any witness in this type of environment. You just can't be effective. What would your position be with respect to evidentiary motions over Zoom when you're a Superior Court judge?
What I would expect to do is what I've been doing all along. And just as a complete answer, I agree with you that we were sort of forced this issue overnight. No committees, no anything. Literally went from shutdown on March, whatever it was, 9th, 10th, 13th. I don't remember the exact
I think it was 6.
shutdown, something like that. And then it's okay. We're going to reopen, and there's this thing called Zoom. And if you ever told any of us a year ago you'd be doing such a huge volume of your business on something, a platform we've never even heard of, we would think you're crazy. And I'll complete the answer further by saying I'm on the District Court Judges Technology Committee, and we looked at this issue several years ago about trying to do Section 35s remotely. Would we be able to coordinate with the clinician in the hospitals remotely to keep people safe in a hospital? This is well before COVID, and it was in sort of study for a long time. So all of a sudden, overnight, we have this technology. And I also agree with you that I've had a situation where it was a person who was held at the DOC facility, who was held on a state prison matter, and his lawyer was talking to him and thought he was private. It was being announced on the bridge line in open court. So literally, we're trying to yell at him. He doesn't know because he's talking to his client. Literally, what I was able to do in the courtroom was convince one of his colleagues who was in the court, another defense lawyer. I said, do you have him on your cell phone? Yeah. I said, try to reach him right now to tell him every word he's saying to that client is being broadcast across the courtroom. Fortunately, after 15 minutes of that, the lawyer got the information, got it, and stopped it. No harm, no foul, but it tells you how serious this matter is. And my courthouse staff, there was nothing they could have done. They literally just stopped the computer after about 15 minutes when they thought there was nothing else they could do. And we've had no, formalized training up to that point. So it is a very serious issue. Now, that having been said, our standing orders that have been rolled out, there's been different iterations following the SJC's orders and then following our own district court orders. They give a latitude to the judge to do certain things. But as I read it, most of it is with the consent of the parties. So for instance, pleas, we can take pleas from the House of Correction. We can do it remotely. It works wonderfully. A person is got a relatively minor matter in district court, but they're being held on a superior court case. They can resolve that case remotely if they agree.
I think, Judge, it's working wonderful right now remotely until later on when some of those people are in bringing motions for new trial because it was done,
right.
Claiming ineffective assistance to counsel and other things.
Could be, yeah. They're trying to preserve the appellate record. Of course, we are just trying to get them what they want, which is a resolution case. Getting to your question about forcing a party to do an evidentiary hearing, thus far I've not ever done it. Basically, the Commonwealth in our county may take a different view of processes than any of the CPCS people or private lawyers that we have. Sometimes it's the DA's office that wants to have the in-person hearing. For instance,
I don't think that's the case in the cases that I'm describing. I think it's the judges that want to move cases along.
Right.
That's the way they're trying to do it. They're trying to get something done because they're frustrated doing nothing. And I get that. But I think it results in a substantial violation of a defendant's constitutional right to cross-examination, if nothing else, because I don't think you can effectively cross-examine someone over Zoom.
So it's interesting that you said we've had probation violations, which are different, could maybe looked at a little differently than other evidentiary hearings. But so when we were rolling this out, the first thing I did was talk to a number of lawyers. I talked to the staff people from the DA's office locally, and I talked to a number of people who've been around a long time doing defense work. I said, well, look, what's the objection to doing an evidentiary hearing on Zoom? We could have breakout rooms for you and your client. We could have the opportunity to stop, confer, chat privately with your client. What's the objection? And lawyers basically, candidly, my understanding was some say it's okay in some cases, other cases it can't work. So I've taken the position that if it's agreed to by the parties, not a problem. We'll do it remotely. We'll bring it in. We'll go through whatever colloquy we need to do to make sure that it's as bulletproof on appeal as we can. But if there's an objection, either the Commonwealth, in some cases the Commonwealth does object. For instance, if it's going to be an invocation of a privilege on a bench trial for a case that they don't expect the witness to show up, the Commonwealth sometimes will say, no, we want that in person. Defense lawyers saying, I'm fine doing it on Zoom because he knows the person isn't going to show. So there's that tension. And then there's times when the defense lawyer will say, no, I want to be able to have my client. I want my client to sit next to me so I know the client is saying, hey, that guy in the stand is lying. So if that's the case, I don't force it. I haven't done it the district court. Now, I don't know if this process is in the Superior Court yet where that's sort of suggested, but to me.
It's not suggested. There are judges that are ordering defense lawyers to do motions to suppress and evidentiary motions on Zoom. Some of them are giving them the option of coming in if they don't want to do that. And for a lot of reasons, people don't want to come into court right now because it may not be safe. It might not be the lawyer themselves. It might be that they have a 95-year-old mother at home. And judges are saying, well, if you don't want to come in, then you're going to have to Zoom it. There's 2 cases up on appeal to the SJC right now with respect to that. This is not a situation where, and it's happening all over the place in Superior Court. This is not a situation where the 2 lawyers are saying, okay, let's do it. And I could see sometimes where we do that because it's the only way you can get your guy out of jail.
Right.
You know, but that puts you in a bad position too. But if I'm sitting here saying to you, you're sitting on the Superior Court, I've got a drug case, my guy's not in custody, or a gun case, my guy's not in custody, you want to move the case along, and I'm saying no, are you going to be ordering me to go forward on Zoom?
Not likely. The reason is this, because above all else, we have to make sure that the process is fair and that it works as it's supposed to. Now, it's difficult to answer that in isolation because I know there can be other factors. For instance, if the judge is making it available in court, one way to look at that is saying the judge is being ultimately fair, saying you can come into court or you can do it Zoom.
I don't see it as fair. It's an option's choice. You have a choice of putting yourself or your family at risk or giving up your client's right to effectively cross-examine someone. Those are your choices.
Well, no, there's a third choice. The third choice would be to continue the case. And I gather what you're saying is the judge has made a decision. I'm not going to continue the case because you can either do it in the court or you can do it by.
Right. That's what's happening.
Right. And then the question is, why is it that you're not giving the continuance? Is there some overarching principle that would sacrifice the
case is old? You want to move your docket.
Yeah, but look, I've been on rocket docket sessions. I've been there. You know, when I was at the Industrial Accident Board, we had 10,000 case backlog. Call them the rocket dockets. I've been in district court. I'm actually chair of the case flow management committee in the district court. And talk about a challenge. How do you move cases during COVID? Right? It's an oxymoron. So this issue has made its way up to the SJC. For instance, dangerousness hearings. At the dangerousness hearing, the Commonwealth says we have 120 days to get this case tried. But Judge, you're not letting us try the case if you won't let me do the discovery work. So therefore, we want the defendant held beyond the 120 days. Of course, the defense lawyer.
SJC has said it's stayed.
Correct, but is it stayed forever? Is it stayed for 2 years? I mean, if the client's still in custody.
I don't know. I don't agree with that either, but that's a separate issue.
But it's separate but related in that it still goes to the issue of timeliness. Is the timeliness of that case more important than the substantive rights of the parties? And thus far, I've seen no, that is not the case. So to me, I would not think that in the normal circumstance, I would order somebody to go do an evidentiary hearing over their objection because of time standards during a global pandemic. It just doesn't make sense.
Okay, so what you're saying is you would never order someone to go forward on a motion to suppress where the issue is just moving your docket.
I can't say that because I don't know what's going to come. What I can say, and I, you know, this is some of the political love. What I can say is that I can't envision a situation during a global pandemic where expediency and docket control would preempt the substantive rights of the parties. I will say that every single case, bank on it. I can't say whether I would ever disallow a motion to continue under certain circumstances, but I will say that never should expediency override substantive rights of the parties. And so, taking your example, if pushed, I would not force that case, and I would probably continue it.
Okay. I have a problem in the district court, especially with the lack of consistency in terms of how we're handling court closures and how long they're closed and quarantining. Last week in Chelsea, they closed on Monday because a police prosecutor tested positive. They closed for 2 days and they did a quote unquote cleaning. which, you know, people think that there's some special company that comes in and is spraying everything, doing this deep cleaning. And it's the hardworking custodians that are wiping things down, basically, which is not really the type of deep cleaning that people envision. That's number one. So they closed down for 2 days, Tuesday and Wednesday. I'm using that as an example because I think there was about 5 district courts last week that were closed because somebody tested positive.
Including mine.
Huh?
Including mine.
Okay, then there's 6, okay? Which puts, you know, when people are testing positive, it puts everybody who's in contact with them and their families in danger. Because a lot of people aren't physically going in the court, it's mostly the employees, the court employees. But so they closed for 2 days and in Chelsea. They reopened on Thursday. Friday, they discovered someone else tested positive and they closed again. I actually talked to Judge Masher about it because I was walking into the courthouse when the court officer said, "Turn around, Terry, we got to close." Someone else tested positive. It's not about wiping down the counter because with this disease, it's about the people who are exposed to it from someone who tests positive. The CDC says they're supposed to quarantine for 14 days. And when you reopen a court 2 days later, it's the same people there that were exposed to everybody. They're exposing other people. They're putting themselves at risk. And I just don't get that. And there's a complete lack of consistency from district court to district court to district court in terms of how they handle these things. If I go over to Somerville, they're not letting anybody in the building without special permission. If I go over to Malden, they take the position that anybody who wants to come in that building is entitled to go in that building, that they don't have the right to stop them, okay? So you know, and I can go on and on and on about how every court's handling everything different with the pandemic. Do you have a view in terms of that, in terms of how things are being handled in the district? I'm talking about the district court because that's where you are. The Superior Court I could talk about too, but let's just talk about that.
So, telephone number I could give you, but of course that's not going to answer the question because.
By the way, I already talked to Judge Budd about this, so I think I got the direct line in terms of that.
Ultimately, right. It goes ultimately. We are like any other organization. The judiciary is struggling with really an unprecedented challenge, and you look at this nationally. Look at the national stage debates. You're watching all the presidential stuff last night. Across the entire globe. Certainly me as a candidate here today, not going to be able to answer any questions because we try to deal with things as we can. But what I've done in the district court, my district court that I have direct control over, is I've tried to envision with my staff, we need to, number one, open communication, not just with us, but with the bar, with the lawyers and the public that we can.
I just want to comment on that because one of the things that's happening to the court, and I've talked to a lot of bar advocates about this, is when the judges talk to the bar, they're not talking to me as a private lawyer that's not on the list, that's not on, that's not part of CPCS. They're not even talking to the bar advocates a lot of the places because I get the complaints. They're talking to CPCS. Well, CPCS doesn't speak for everybody.
Right. Yeah, I mean, that may be true. We have bar advocates, we have CPCS. And I'll tell you frankly, since Zoom is an opportunity to have teaching moments, what I've done, you've probably been on some of my Zoom sessions down in Attleboro, is I'm looking at 68 Zoom participants. Those are all the cases I had in our first session on that morning. And I use that as the teaching moment. So for instance, if we have, and in the early stages in particular, what I would do is I would say, look, what are the ideas? And I would hear from people to say, well, maybe we should have an attorney Terrence Kennedy morning. So we would batch up Kennedy's cases and try to get 8 or 10 of his cases done on a particular day. But no, they don't do that over in another court. And so ultimately, all this sort of trial and error, all these issues get floated to ultimately our management team, whether it's the court administrator, whether it's the overarching trial court, whether it's the SJC, whether it's our.
In terms of that, because when I talked to Judge Budd about that, and I talked to another SJC judge about it as well, their response, both of them had the same response, that it's not getting communicated to them, the problems, that they're kind of disconnected from it and they're not hearing it. So they don't know what's going on. That was their response.
Could be.
So, which was the next question I was going to ask you, but you brought it up. It's not getting there. They're issuing standing orders without hearing from you, without hearing from the bar.
Well, I can speak for my chief. I got it right on my phone now. We talk. My Raj, who just retired, we've done really, I think, a remarkable job of getting people and their concerns addressed. And yes, there's always some issue. You know, should you
I've done a remarkable job on the technology side.
No. I'm talking about even the educational piece. That even the reaching out, the getting information, using. I mean, if you think about what would happen in a normal circumstance, we have bar associations, we have meetings that we do. You can't do those now. So I'm personally using the Zoom platform as an opportunity for us and the judges who routinely come to my court to educate. And I'll give you, for instance, I don't really like to trot this up, but we had a mistake last week. Our clerk's office was under the impression that the new standing order meant something was going to happen with transferring cases to a different court. And that wasn't the situation. I found out about it because one of the lawyers gave a text. Before a year ago, when did you have private text with practitioners? I get it all the time now. I get a defense lawyer, I think, or maybe one of the DAs who said, hey, I just heard that my trial matter is being assigned. Judge so-and-so assigned it over to that court. Is that what's happening? It gave me the opportunity to go in, clarify the misunderstanding. I even reached out regionally to our new Raj over in Brockton to say, did I miss a memo on something? And so we nipped it in the bud right away because there's communication. I have never had email and text communication with private lawyers as a judge until now. And that does have
and I've experienced that as well.
Yeah, and that gets to be a problem because sometimes, things don't get, they go into an outbox, I don't see it, and I don't have support staff that screen this stuff. So if a lawyer sends me something, I generally get it, whether it goes into my trash or not. And I hate being responsible for something that really is an administrative matter, but during COVID, have at it. That's what we do. We try to get the word out as best we can.
But getting back to the safety issue, you indicated that you had to close your court last week because someone tested positive or was exposed, right?
Yeah.
Was it a positive test or just someone exposed?
No, it was someone who was positive.
Okay, so someone who worked in the building was positive, right?
He was a private lawyer who was there that day. And frankly, during the Zoom hearing, he got onto the Zoom hearing the next day and reported it publicly. So that we knew about it instantaneously, which was good. And then it gave us the ability to sort of get that information. And then we just followed the court protocol, which is the closure and the cleaning, et cetera.
Well, okay, so you closed on the cleaning, but what about the people that he was exposed to? That were exposed to him? Did you do contact tracing? Did they go into quarantine?
Our court doesn't do the contact tracing. That's done the executive.
Well, that's a problem too.
Right, but we don't.
Wait a minute. This lawyer goes into your court, right? He walks through the door. The first person that he has contact with is security. Okay, and as he goes through security, he's certainly within 6 feet of those people who are checking his temperature. At least one person, right?
Right.
He walks through security. He goes in there. He may see a court officer that he's friendly with, say hello to them, right?
I'll give you even more. This lawyer was in the first session all day. He came in.
Okay. So he's in the first session all day. He's
went to probation. He literally has had the opportunity to have contact with almost every person in the courthouse.
Why isn't everybody in the courthouse under quarantine for 2 weeks under the CDC guidelines?
Well, we take our marching orders from, and again, this is above my pay grade.
But that's my criticism. That's my point. Not you, but of the court system. Dr. Fauci has said when you're exposed to someone who's positive, you're supposed to go into quarantine for 2 weeks. Or at least if they're not going into quarantine for 2 weeks, why isn't everybody going out and getting tested before they come back to court? Because the next person who goes into that courtroom, me, for example, I'm 62 years old. I'm not a young man. That automatically puts me at a high risk. I'm dealing with that same security personnel. I'm dealing with that same probation officer. I'm dealing with that same clerk within 3 days. People who are potentially exposed to COVID that can get it and expose me. Do you think we're doing it the right way, Judge? I don't.
So, I mean, it's not for me to criticize. It's my job. to take up for the protocols. And again, this is
Well,
something
okay,
that's
wait a minute. And I'm beating up the messenger. I'm already voting for you, so don't worry about that. But I'm beating up the messenger.
Take the beating.
Following orders is not an answer. We're talking about people's lives. We're talking about public safety. We're talking about exposing everybody from the defendant that's in the dock to the court officers to the great people who work in your court. And we're not following the CDC guidelines.
Right. On the other hand, what I'm told is that we are following the guidelines.
Judge, there is no other hand.
Well, so
there is no other hand. We're exposing people. Judge Mashira, by the way, after I talked to him, closed down for 2 weeks, basically. He is not allowing anybody in the building for 2 weeks. And it's the honest to God truth that we're putting people in danger. And I'm not going to belabor it with you anymore. But it's the honest to God truth. We're putting it in danger because we're just trying to keep things moving. And I get that, but it's not worth the price.
All right, but it's not just a question of keeping moving. It's a question of access to justice. I mean, we close. And when we do
this, you don't have to close anymore because you can have what we have here. Okay, exactly. But those people that were exposed should be in quarantine. Period. There's nothing to talk about. If I go out today and I run into somebody and I go into Tony C's restaurant, they take my name and number for contact tracing. Somebody in there is exposed that they find out about. They call me and they tell me somebody's been exposed. My obligation at that point under Charlie Baker's orders in the CDC is to go into 14 days of quarantine.
Right. If there's a known exposure.
Courts can't do what Tony C's doing.
Well, right. Again, if it's a known exposure, the issue, of course, that we hear is that
known exposure. We have the lawyer that came in there.
Right. Did he expose? Like for me, for instance, I was never in the session, never had an opportunity to see him. Am I considered exposed? I don't know.
Call the people that were.
Well, right. If I pick up a file, how would I know that he touched it or didn't touch it? Right. So there's a possibility I could be exposed, I suppose. And then the other side of that, of course, is that this lawyer made it easy because he told everybody. The question now is, what obligation do we have to not disseminate somebody's, condition?
Well, you don't have to do that. You only have to say somebody came into this courthouse that has COVID, and you've been in contact with them. Go into quarantine.
Right.
That's protecting the people that work for you.
Yes,
it's protecting the lawyers in the building. It's protecting their families. It's protecting their 85-year-old mother.
Yeah.
I'm not going to belabor it. Yeah, you've been a great, and I'm sorry I beat you up on it because it's a pet peeve of mine. And this was my opportunity to say something. You're a great judge. I've been in front of you many times over the years. You have a great reputation. I told you that my very, very good friend, Judge Barrett, already beat me up. The first thing he did when you got nominated was call me up. So it was been my friend since I was 17 years old, and he was all over it. I've gotten a number of calls about your nomination, and I told everybody, we already know he's a home run. Don't worry about it. I'll be voting for you next week. My questions weren't really directed at you with respect to COVID, but at the trial court. And I've had this conversation with the Chief Justice, and I've had it with other soon-to-be Chief Justice, but I expect, as well as Chief Justice Dolly. I'm going to keep pounding it because I think we're putting people at risk.
Well, and I say this without pandering, that it's great to have advocates like you, because without advocates, things don't get done. So I never. This is not a.
That was pandering.
I love the rough and tumble. I love it. That's what we, as you know, you've been in my courts, and I love a good argument. Absolutely.
All right. Thanks, Judge.
Thank you, Counselor.
I think I'm the last one. Okay, let me just pick up a little bit on Counselor Kennedy's issues with regard to hearings. I've been on a bunch of hearings on the Zoom, and what I notice is that the witnesses, if they're police officers, usually have their report in front of them and are looking at it as I ask a question. And I've been on a hearing where with a couple of assistant DAs who kept looking up out of from where the screen was to obviously get, in my opinion anyway, get some sort of direction from somebody else in the room. So that's why I don't think it's fair to have hearings of any kind of substantive nature on these Zooms. And in addition to that, you as a judge don't get to see the witness and don't get to see how they react to questions or how they answer questions. Because, you know, we are humans who have grown up for thousands and thousands of years of looking at people's faces and reading them. And we pick up a lot of things from how somebody looks or acts or the way they answer a question. We lose that with these videos. And in addition to that, you get areas like we even have it here where the voice doesn't match the lips at times. So you get a false reading at looking at a witness. And I think it was the Amaral case that held for the proposition that every defendant accused of a crime has a right to face the witness, not with any kind of a screen or anything blocking that. And these videos are good, but they block a lot of important information coming from these witnesses. So I do know judges in the Superior Court that have given lawyers hard times about not going forward on a motion to suppress where it wasn't a four corners motion, it was a witness motion. And indicating we're going to have the witnesses on Zoom, a lawyer objected to it and strenuously, and the judge finally backed down, but it wasn't pretty. And for the life of me, I don't understand why a judge would get upset about that unless that judge had no experience as a lawyer in a courtroom. So I know it's hard for us now. We've got clients that are in jail. We've got clients that want to have hearings and trials. I understand that. But I think we're going to give up an awful lot if you're talking about somebody getting a fair and just trial or a fair and just hearing. We give up a lot of that by having to demand Zooms. So I heard your response to that, and I appreciate it. But it's going on, and for the sake of, especially if somebody isn't in custody, for the sake of we got to get this trial done. And we'll do that, but we'll take away a lot of important rights a defendant has. I don't think is right, but any comment on those things?
Yes, so I do. I have a pretty strong opinion. The Sixth Amendment right to confrontation, harking back to Sir Walter Raleigh and those lines of cases, it's very important. But what I would say in response is this, that the court system, like anything else, evolves over time. And I have no doubt that when we look at things like of trying cases, that we will ultimately arrive at a just and fair way of handling these. And by that, I mean, you know, we had awful problems with drug certifications, right? I don't have to go through and open all that up, but every one of you who does any criminal defense work knows of all of those problems we had. Horrible problems, an assault to the system, but judicial expediency won't let us paper over that and say, well, look, if you know the client was probably guilty when he took the plea, but because of a taint that occurs at a crime lab, we'll just paper over it. No, the judiciary instead went through, and ultimately, I think most of us would say it was extremely time-consuming, cumbersome, embarrassing. But those cases ultimately had to get through the system, and whether it results in an acquittal or an allowed motion for a trial, whatever the case may be. And then we move into the OUI cases. And I know you both have done OUI cases over the years. And that's another example where there was a challenge. It's like, no, you can't really challenge the breath test. Come on, it's bulletproof. Everybody accepts it, no problem. Well, we know the Ananias cases and the progeny, where that left us in the Commonwealth. So I don't think Zoom hearings, whether they survive constitutional scrutiny or not, I think ultimately those issues need to get vetted. And we as trial judges have an obligation to make sure that if a case goes up, it goes up for the right reason, and that we've made a decision that is sound. And ultimately, if a judge says, no, a Zoom hearing is constitutional, there's enough there to survive constitutional scrutiny, or another judge says, no, it isn't, it is clearly a violation. The best thing we can do as trial judges is to clearly articulate the record so that on appeal, the issue is properly framed. And ultimately, you may have something like in an IS litigation on the issue of whether or not there's a sufficiency of the evidence that goes to a constitutional level.
Yeah, I do think, though, that judges can play more of a role. Let me just go back to the certs on the drug certs. When I first started practicing 42 years ago, when you got a drug case of any significance, even smaller amounts of drugs, you invariably hired a chemist. And there were some retired state police chemists that made a pretty good living at examining those drugs. And they'd go into the lab and they'd go through the whole process. And those were sort of standard for years. And I will say, I think us defense lawyers got a little lazy and lackadaisical also, because it seemed like, there was hardly ever a case where they said, no, it's not the drug, it's some other item. So you got laxed in it. You didn't follow up with the drug analysis. And then before the scandal hit, I don't think very many lawyers, I don't remember them ever even asking for funds for a drug expert or a chemist. And I think we all kind of said, well, what's the point? Well, we learned a good lesson what the point was with what was happening. And probably some extent of the breathalyzer too, although the breathalyzer is a little different issue in my opinion, because you can always make a good argument, I think, that the machine is nothing but a piece of junk and it doesn't give what it's supposed to give. And you can have some success with that, I think, in front of a jury. But so, yeah, I think we should get probably back to that and understand that the more that we take things for granted, somebody is going to do something to foul up our system a little bit. So I don't know, but I like to see judges that would say, notwithstanding what the Supreme Judicial Court rules, you are a man who, I think, my experience with you for years in Attleboro and some of it in Taunton years ago, you were extremely fair. And that I think is one of the finest qualities of a judge, is to be fair. So if I'm a judge and I know what the SJC rules, let's say on a video, but I don't think it's fair, I can say to myself, I'm not going to have a trial with that, because I don't believe it's fair. And my job is not to just follow what I'm told. My job is to make sure every citizen gets a fair trial. Judge Harrington in the federal court stopped using the guidelines in the federal system because he said, they're so unfair, I'm not going to sentence anybody under those guidelines. And he and other judges throughout the country that did that finally led to those not being mandatory anymore, just the discretion of the judge. So I think sometimes judges have to be bold and go out of the box and say, I'm not going to do that. Judge Faison did it with a guy who had a 10-year minimum mandatory, which she knew, the lawyer knew, the DA knew, everybody knew it was unfair. But she was the only one that was going to be able to stop it. And she did for a while. She refused to put that sentence on this person, this citizen. Of course, it was overturned, but she made her point. And if every judge did that, that law would have been changed pretty quick, in my view. In any event, I think you're one of the finest judges I've ever been before. You're There are some maybe better than you, but I don't think so. You are right at the top, and I mean that. I have never heard one bad word about you in all the years you've been sitting.
Right.
And going to Taunton Court for the years, and again, the old Taunton Court, Attleboro, many, many times in front of you, both in the first session and the trial session. You know, usually you hear things from lawyers like, oh, this person, this judge is this way, or is this. Never once, ever, did I hear a bad word mentioned about you at all, which I think is a great testament to your awareness and your temperament and the way you handle a courtroom. You make everybody feel, every defendant and every lawyer feel that you listened to them and you were fair with them, and you treated them fairly. And that's a tremendous asset as a man and as a judge.
Thank you.
So when my daughter found out that you were nominated, she said, "Is he coming to Brockton? We loved him in Brockton." So, and the lawyers loved him, she said too. So hopefully you'll get back there after you get on the bench. But I don't think you're going to have any problem with my colleagues and myself. You're just a super judge. So keep up the good work.
Thank you so much for those comments. Really, I'm very humbled by all the comments. Terrific.
Well, we wouldn't say them if it wasn't true, that's for sure. I mean, a lot of people get nominated and come up here and they don't do too well with questioning and everything else, but you're just you should be a mentor for every judge.
Thank you.
So with that, anybody else got anything to say?
I just want to reiterate what Bob said. I agree 100%. That's been my experience as well. 100%.
Well,
And
with
we don't always agree.
that, we're going to end the meeting. We're going to vote on you next Wednesday. And I think it'll be a...
I'm sorry, that just cut out. That just cut out for some reason. I'm sorry. You said it was a vote next. Did you say next week?
Yeah, next Wednesday, Thursday, we're going to be in session, right? Aren't we next Thursday? For the SJC nomination?
Yes, on the 12th.
Yeah, so we'll vote, I think, on that day, or unless we have a hearing on Wednesday and vote Wednesday, but obviously you're not going to have any problem, and I'll be very proud to vote for you.
Thank you so much.
So that's it. Have a great day, everybody.
Thank you. You as well.
Adjourned.
Okay. Thanks so much.